Township Attorney recommendation to provide a counteroffer for purposes of resolution to plaintiff's counsel in both Webster Township versus Morningstar Ventures LLC, number 23B000008ON, ending in 1480-3 District Court for the County of Washington, and Webster Township versus Morningstar Ventures LLC, number 26000065-CZ, pending in Washington County Circuit Court.
Second.
Okay. Discussion? Okay, roll call. Shelley?
Aye.
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 Carried. Let's see. Turn to board member. Okay. I'd like a motion to adjourn, please.
Move to adjourn.
Second.
Okay, all in favor?
Aye.
Okay,
We'll take a 5-minute break.
that's the plan. 5 minutes.
Start in the half.
It's not important. Oh, yeah. Yeah. Do you think it's bad? I don't really usually care. You're right. My husband. Yeah. Oh, I know. But this is, you see why I'm checking because I have house. Oh, there it is. Oh, Darius. Nice. I don't drive because I don't care. Go to my coach right now. Someone's got you. Which one?
ran out, so a couple of residents and one person. So while you can get your vote, I'll just go back.
All right. It is 6:35. And we will start the special meeting. So first, pledge of allegiance to the flag. Pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Supervisor remarks. I'm pretty sure you all know why this special meeting is here. So we're going to talk about the draft private road ordinance. First, we're going to get kind of an overview as to why we're working on this. Then we'll have a presentation about it from Sri, and then we'll take public input and questions and answers. Okay, that's about all I have. Approval of agenda.
Move to approve agenda. Support.
Okay. Discussion. All those in favor?
Aye.
Opposed? Okay. So, if you want to, Sri said something about you or one of you guys saying some of the, oh, you,
I can get the
so Shelley said a lot, I'll just start with this. Shelley said a lot better than I did the last time she talked about this. But so why we're doing this is because our current private road ordinance has a lot of flaws. First of all, I personally don't think it was actually really designed for any of the stuff that we needed to do, apart from brand new things. And it has a lot of problems in it with so the one thing that I've noticed from everyone talking to me over this last year, basically, is that one of the really big problems in our ordinance right now is like the absolute, you gotta have a maintenance agreement. And according to what Sri told me, we are very limited even in granting a variance on that. Although we could do, other things like, okay, maybe it doesn't have to be this wide or whatever. So, and it is, well, it was catching everyone who had, there was a lot, you buy a lot, it'd be on a road, and then you couldn't build your house unless you jumped through all these hoops. We kind of fixed that to some extent, just as a stopgap measure, but that's one of the reasons that we're doing this, is to basically grandfather as much as we can. So we'll talk a lot more about that, I think, over the course of the evening, but I don't know, Shelley, you got anything else to add? It's like,
I think this is just an example of, Sri talks to the residents a lot and can recognize when one of our ordinances isn't good and isn't helpful to residents. So she brought this to our attention so that we can try to fix it so people aren't having to jump through very expensive hoops when they want to do something on their road. And balancing that between, safety, so.
I mean, from my perspective, it's a lot like what we had to do with the animal ordinance. Even though we're still regulating it, it's a lot less draconian than we had the first one. Okay. Well, yeah.
Yes, from my standpoint, I mean, we can talk, how long have we been talking about this now?
we said 30 minutes for the presentation. I said myself 15 to 20.
I mean, we've been talking about
Oh,
Over a year.
Right, so a long time. So
August 2024 is when we started talking about it.
So there's three main topics, at least from a management standpoint, that I think is really important to understand. One, in the current zoning ordinance, if you're on a private road and you want to build, you have to then fix the whole road to the ordinance as it's specified. One, that's a heavy lift, right? It's been years we haven't enforced. We don't want to take down trees. We don't want to reroute power and all that. Cost effectively, or it's just not cost effective to do that. But then to add insult to injury, after you do all that, You then have to get with all your neighbors and get them to agree to help pay, and everybody has to sign a maintenance agreement. Right, so that sounds like cruel and unusual punishment to me, to get everybody to have to do that. So it's just simply not fair. So the grandfathering is something we talked about. So if you're on there now, all that is taken care of. If you then split, you know, the same logic then applies. I mean, should you, one split, be expected to fix the whole road? That's not reasonable from my standpoint either. Now, is there something, a turnout that could be put in, or is something unreasonable? That's the reason there's all the language that's in here, to be able to address that and work with the residents to find some happy medium. And then the same question, if it is split, you don't have to go talk to all the other neighbors on the roads, just whoever the new additional ones are, would have to come up with a maintenance agreement. And it's that basic tenets that we've been working on to flush out everything we have now. And we'll talk about that coming up. There'll be time to get to it. Okay, so, or we can talk after.
Wait, no, we're not at that part, sorry. We will get to that part.
I just have a question.
Huh?
I just have a simple question.
Oh, yeah, go ahead.
What if the road's already up to county specs?
Yeah,
It's not a simple question.
if it is or is not.
Is.
If it is, then there's nothing that has to be done, from my standpoint.
Sorry, yeah. All right. Okay, so, Sherry, could you please?
Thank you. I just wanted to make sure, are everybody able to read the screens, okay, with the lights? Okay, perfect. Hi, I'm Shri. I see familiar faces in the crowd, and I see some new faces. Thank you all for coming and giving us an opportunity to explain what the ordinance is about. I was having these slides lined up when board members talk about the why. As I mentioned, we started working on this amendment since August 2024. It's getting close to 2 years. It's because the current ordinance is very restrictive and it gives very few opportunities to allow for variances. So the aim of the draft that is under review right now is to find a balance between trying to get some safe access and then also provide flexibility to allow for variances that are not just based on practical difficulties of the land. Because the board, as they mentioned, they've heard from many residents, they've reviewed quite a few variance requests, and then they realized how restrictive and confusing the current ordinance is. So the goal, the guidance, the policy guidance the board has given me to help them come up with this ordinance is that all existing roads are grandfathered. They stay as they are. They're not considered violations. The ordinance itself says that. The only time an upgrade might be required from an existing roads that are grandfathered is when somebody's proposing a new lot split. They wanted to add, another lot. Well, even 1, 2 doesn't matter, but if they have more lots, then that might trigger the review process. It doesn't trigger entire upgrade, it just triggers the review process. So the board can question and analyze its situation case-by-case basis and figure out what might be required.
Can I jump in? Can I jump in with you? Yeah, so there's also, throughout the language, there's a reasonableness standard that's put in as to what would be reasonable. I mean, so you're going to find figures that are in the document that show, what are we, 20 feet wide, ditch width?
Right, yeah, we're going to get to that. But yes.
So when you see those, just keep that in the back of your mind, though. It's designed for you to be able to come to us and talk to us about what is reasonable. And that shows up routinely through all this discussion.
That is true. Thanks, Brent. I think the recurring theme of the whole document is everything is grandfathered, but when somebody's either doing a new lot split or a special land use or a site condominium or any kind of a large development, then that would trigger application of the private road ordinance. So the new ordinance, the roads are essentially classified as 4 types. Private roads, which serve more than 3 lots. Every road that serves more than 3 lots is considered a private road. Any road that serves 2 to 3 lots, but the number of lots are counted from where the public road is, not where it branches off. That is called a shared driveway. And then we have non-conforming access, which means They may have been legally established, they may have received road permits from the board, but they may have some lapses or oversights because of which they don't meet all the standards. They are called non-conforming access. Non-compliant access are private roads that have been established over many years. I do want to take a small pause. So the private road ordinance was adopted by the board in 1992. So there was no private road ordinance before 1992. So non-compliant access might have been roads that were built before 1992 and then they just organically expanded or extended or driveways have branched off of it. So they are considered non-compliant access ways. So the current ordinance is divided into 5 sections. We have the general requirements that just talks about, as the name suggests, very general. The second one talks about development procedures. This is mainly geared towards new builds. If somebody wants to do a new road or a new shared driveway, the procedure are essentially geared towards that. And then we have general and design standards that have what are the standards that are required for new construction. And those standards may be referred to when the board is reviewing the non-conforming and non-compliant access upgrades. And then Article 3, I will get into a little bit detail about that, but this new ordinance also has a lot of tables, tabulations, figures, just to make it easy for people to understand what the text actually means. Article 4 which is the major policy change that the board has been working on. As I mentioned before, the theme is that every existing road is grandfathered. Selective upgrades may only be required if one of those 2 things happen, and what kind of upgrades are required is determined through a very selective process so that the results are consistent, and board has some guidance. So that's all laid out in Article 4. And Article 5 is typical administration and enforcement that talks about what happens if you want to appeal an administrative decision, what happens if you have if you want to make a complaint on a road, what are the enforcement strategies. Those are all those standards. Just wanted to summarize, also wanted to thank the board for the patience and their diligence in all these discussions. We have, since 2024, we have reviewed many other communities' ordinances to understand how they are dealing with situations. We've went through different permutations and combinations, what would work, what may not work. The township staff has conducted an existing inventory of all private roads and most of the shared driveways, which may be non-compliant in the township, and we have about 45 of those. And we evaluated accessibility based on how they are right now, just to get a sense of what is the size of the issue we're dealing with the township. Those assessments are not final. Those assessments are not any determinants. They're just that assessment is done just so we can grasp the size of the issue. And we've also, in the initial stages, worked with the DAFD to understand what works for them. Okay, so when is a permit required? This question is essentially saying, when does the private road ordinance apply? So when somebody wants to do a new construction of a road, shared driveway, then we would open up the private road and say, okay, this would apply. When somebody does extensions of new and existing roads, or when somebody requires any discretionary upgrades associated with the land division. And in a very, very rare occasion, if a total upgrade is required by the board, after all other options are exhausted, that's when a permit might be required. When a permit is not required, when you don't have to worry about upgrading the road or don't have to worry about complying with the road standards, if you want to build a house or an accessory structure on a pre-existing vacant lot. If you have a lot which is vacant right now and you do not intend to split it, all you want to do is build a house, you can build a house without upgrading the entire road. Or going through the whole maintenance agreement process This is a big change from the current ordinance, because the current ordinance makes one resident who wants to build a house work with all the other residents to apply for a permit, bring the road up to standards, get a maintenance agreement in place, all to build one house.
Yeah, which is functionally impossible, right? So it results as a taking, in essence. You can't build.
Right. So that is a big change with this draft that is being proposed, that if you're building a house, then you're fine. We will just do a site inspection, send a letter to everybody on the road saying, hey, they're building a house, we did a site inspection, these are the items where the road is lacking in terms of compliance with the standards. Just an FYI. And it's up to you guys if you want to do something about it, or if you wanted to work with us to do something about it. That would be a choice left to the residents at that point. You don't need a road maintenance upkeep. You don't need a permit for road maintenance or upkeep. And single access driveways, if you're just talking about one driveway, that is, as long as it has frontage, accessing your house, this ordinance doesn't apply. So big changes, which are positive changes, which what I heard from the residents that, okay, this is really, any of these things which I'm talking of before, they used to have to come to the board to get those approvals. But now with this change, they all can be issued administratively. If somebody wants to just split a lot for sake of property transfer, or they just want to do it for estate management or something, but they don't have any intent of building anything on the property right away, the existing ordinance still requires you to go through the process, build a road, even if serving nothing. The new one allows you a deferral of designing the road and deferral of constructing the road until you decide to build a house on the vacant lot. What the new ordinance does is it keeps the protections in place. It will ask you to make sure you record an access easement. It will ask you that you record a standard basic maintenance agreement, which you can do it later, and then it will allow you to defer everything until you build a house. And that deferral can happen administratively. We don't have to come to the board. Administrative extensions of road permits. Once a permit is issued, the road construction has to be completed within 18 months per the current ordinance. But the new ordinance allows extensions administratively if there's a reason. Am I too fast? Am I going okay? Perfect? Okay. I'm also trying to keep track of time. Pre-construction and approval process. So these are pretty much kind of a standard procedural, but which the current ordinance doesn't give us much guidance at all. So we just provided some standards in there. These have nothing to, these are more for administrative and administration of the ordinance. So that whoever's in my chair in the future, we all apply the same consistent process. The residents know what happened, step 1, step 2, and step 3. That's what these changes are about. The current one has no guidance, and we're providing more clarification. With regards to design standards, this is more for new roads and may be used for selective upgrade discretionary standards. The current ordinance requires every new road should have a cul-de-sac, and the hammerhead is permitted with a variance. The new one allows hammerheads without a variance. You don't have to justify practical difficulty to get a hammerhead with the new draft. There are more streamlined standards. We had about 12 tables in the current ordinance. They're all streamlined into 2 tables with this new one. And we have images of cross sections. We have more cross sections and images and tables to explain things better. We did add the board did consider new standards just to keep, like this ordinance, like I said, was adopted in 1992 and very few amendments happened since then. So there are some new standards that were introduced that if somebody is doing a development that is more than 30 units, you would require a second access for fire and emergency purposes. In terms of respecting protecting our environmental features and natural features. And based on our master plan recommendation as well, there is a prohibition of using coal tar pavement if somebody is proposing an asphalt road, if they are proposed. And then we all have so many no-name roads within the township. The fire department did express a concern that sometimes when they get a call, it's really hard for them to figure out where it is because most of the roads have no name. So that is a requirement now for new roads only. We're not going to go back and ask everybody to name the existing ones. These are requirement for the new roads only. So shared driveways is a big change because the current ordinance did not give any guidance, which is why we ended up having a lot of roads that are not wide enough and they're just all over the place, not consistent application. So what we did with this current standard is we provided some minimum requirements for shared driveways. If it's up to 800 feet, 16 feet wide is required for the travel way. If it's more than 800 feet, then you would require 18 feet. There's no length limitation for a shared driveway. It can be as long as it can be any length, as long as it only serves 3 lots and it meets those width requirements. The access easement required for a shared driveway was 66 feet before. It is now reduced to 40 feet. How is that helpful? Is the building setbacks are measured from edge of access easement. When you're reducing the access easement, your front yards are reduced, so you have more space to build. So that's a change. And hammerheads, like I said before, they are allowed administratively. And we did introduce the same private road standards for a shared driveway as well for the roadbed. The reason behind this is that if the shared driveway ever turns into a private road, like if the 3 lots were split into 6 lots in future, it is ready to be converted to a private road to serve more number of lots. There was also not much clarity in the current ordinance as what can be approved administratively and what can be approved to township board. The township board with this current draft, they have allowed certain like approvals of shared driveway permits can be approved administratively so that process can be quicker, that they don't have to wait to get on the township board agenda, they can be done administratively. If a road is part of a site condo, then the planning commission reviews and approves that. If it's any private road or any variances or any appeals from zoning administrator or any enforcement decision, that's when township board comes into play. I think I went over this a little bit, development procedures. Right now, the current ordinance just like randomly, conceptually high level says you need to do this and do this and do this, but not which resulted in not consistent administration of those. The new one just talks about, okay, these are the steps, this is the order that happened, these are the conditions, what you need to apply, check the boxes before you go to the next step. The administration and enforcement is also a slightly, I wouldn't characterize it, but it is also a policy change that is reflected in the current draft, which is barely discussed in the current ordinance. It talks about if you're not, if you don't like something, a decision that is made administratively, you can come to the township board to appeal. You don't have to go straight to the court. There are some minimum maintenance expectations included in the current ordinance, and there is a very detailed process listed out for violations. And then how those violations are triggered. Anybody who's on the road can make, and who can make a complaint, and how the complaint will be addressed, how the enforcement process will happen, what are the steps. This is all laid out in this section. This is something I've heard from residents who reviewed the draft, and then they call me and it's like, why is this so long? How many new standards are introducing? I just wanted to say, like I explained before, not many are new standards, but the ordinance is detailed for sure to make sure that there's more flexibility there's more guidance, there are more checks and balances when any decision is made, and to allow for consistent decision making. More words doesn't necessarily mean more rules, it just means more guidance. I think we're done with all the, I think this is what most of you are here tonight. What is the board policy, what is the board considering with this draft as how to address with these non-compliant roads. Any road that's built before 1992 is considered a non-compliant road. Any road that is built after 92 without a permit or that doesn't meet the standards is considered a non-compliant road. What are the standards? It needs to have a recorded easement, a maintenance agreement, and some meet the design standards, the 18 feet width, cul-de-sac, and all that. That's what defines what a non-compliant road is. So I have some couple of examples which are also laid out in the ordinance. Like, let's say you have a shared driveway that has 2 existing lots, and then the property owner is coming in, and then he's proposing to split the third lot into 2. So now that's becoming 3 to 4. So this shared driveway is now being upgraded from a shared driveway to a private road. In that situation, the entire road needs to be brought up to standards. That is the worst case scenario. The whole road needs to be brought up to standards. We will come to the board, and then the board will review it case by case basis, looks at the current conditions, and then figures out, okay, does it really need an entire upgrade, or does it only need selective upgrades? There is a variance process if any of the standard is not met. For example, 18 feet is minimum required, and if your road is 16 feet, then the board will consider that through a variance process and then determine whether 16 versus 18, what makes sense. Any variance request in the current ordinance requires that notices are sent via mail, and we publish a notice in paper, so you will know when that happens.
Yeah.
I mean, not everybody, whoever is on that road.
Let's talk about this one for a minute. Yeah, but the board is allowed, and all the language is designed such that we're able to consider financial hardship. You can imagine if it's been there for, whatever, 70 years, it's all treed in, and power's gone through everything. The expectation is you're not going to cut all that down. Sure, we can find someplace where we can get a fire truck in and get it turned around without having to cut everything down or bulldoze or anything like that. And that's the main reason. If you flip back a couple slides, Sri. Yeah, so one more here, right? So the reason the township board has this and not the zoning board of appeals is that the township board gets to look at the financial hardship question more rigorously, whereas a lot more limited if it was given to the zoning board of appeals and relevant to the planning commission.
So the next scenario is, let's say you have a private road that is currently serving more than 6 houses, and then there are 2 situations in this. One, the property owner who is here is decided to split it into more lots. At this situation, we are looking at where you're doing a land split where you don't require an extension. In that situation, the road is split into 2 parts. Everything that's green, which is along the frontage of the property that is being split, they are subject to the requirements. And then everything that's remaining, which is beyond the current applicant, not jurisdiction, but what's the word? Current applicants, it's out of his hands or his or her hands, that is subject to a discretionary improvement process, procedure by the board. So what are discretionary improvements? So discretionary improvements are not by default required. They're triggered if the board looks at the situation, makes sure, and then makes determination that, okay, the maintenance is poor, drainage problems exist, emergency access is compromised. They have certain standards listed in the ordinance. Please do review them. They're in Article 4. And if the board asks those questions and then makes a finding that yes, this requires some kind of improvements. It doesn't need to be an overhaul, but maybe a cul-de-sac, right? Or it may be a hammerhead, maybe a bypass, or maybe you just need to trim the trees. So this will allow the board to answer the first question, do we need discretionary improvements? Then the board whatever improvements the board decides are needed, they need to be justified based on certain set of standards, which are also in the ordinance. Are these minimum necessary required? Are there any physical, practical limitations? Do we have any wetlands or trees we are trying to protect? What are the safety objectives? So any improvement has to be justified by these standards. So we have another situation where they are trying to split a lot at the end of the road, which would require an extension. So now that road is split into green and red. Green is where the road is being extended, and red is the remaining road. The ordinance also has a flow chart that talks about how this process unfolds. So when we get an application, both happen at the same time. We will have an existing survey is required, and then we need a land division application, and then the township will initiate a site inspection. Our engineer will go on site, and then he'll identify what's the condition of the road is. Then the board will have a meeting, then they'll make a determination of what kind of discretionary improvements are required. And then at that point, you have two outcomes for that determination. You either require just selective upgrades, the road's 80% okay, it only probably needs these requirements, then you only need those two. Or if the road is like really, really bad, then it would require full compliance. But all this happens in a public meeting. For the discretionary improvements, once you have approval, the land division can be granted. But while other things are happening, because the board understands that going through the process of improvements, working with the neighbors might require additional meetings, so the land division will be issued while other things are ongoing and other determinations are being made. Okay, so that's the gist of it. It's a lot to unpack. We have frequently answered questions handouts for you guys. The slides, I'll have these slides available on our website as well. The draft is online as well, and I also left my cards. If you have any follow-up questions, please feel free to send me an email. That's the best way to reach me. And then I'll call you back if that warrants a call. So the next steps, where we are right now. The ordinance is not adopted yet, but we've been working on it, and I think we have a draft I think I'll leave that to the board, what they think, where the status of the draft is. We have sent the draft to the attorney. We received his comments to make sure that we are not stepping onto anybody's rights. And we're going to listen to you all today, answer any questions if we can, the board, not me. And then if the board then directs me to say, hey, Shri, we need to revise this draft ordinance to address that, and this, I'll go back and present them with a revised option at the next meeting, and then hopefully in about 2 or 3 meetings this ordinance will be adopted. And I think that's where we are. This is the QR code for the packet. If anybody didn't have a chance to review it, it's also is on our website, but you're welcome to take a snap if you want to review it while we are talking on it. So we have some guidelines that were also on the agenda with this. Mike?
All right, so now we're at the, thank you, Shri.
QR code, you kind of went a little.
Sure, sorry.
Sorry.
Okay. I can leave it up there. Okay.
Yeah, so I'll just go over this quick. So now we're at the public input, statements and or questions and answers. Hopefully, so please for this part, try to stick to this ordinance. We have other things. We'll have another meeting next week. So one question per person, one follow-up question per person, and then just give everybody else a chance, and then if you have other ones later, then we'll go back. Okay. Otherwise, just generally, just come on up. Okay, so, who would like to go first?
Hello, my name is Doug Kepsel. I live at 7250 Park Lake Drive. And I have one question, and there is a typo, but I don't want my 3 minutes to be.
No.
You can just send it to me.
Okay. So my comment is, first of all, thank you so much for all the attention you've been giving to this. I know it's not easy. In section 1.4 of the new ordinance, it says the existing access is grandfathered, as you mentioned, unless otherwise determined per section 5.3. That would be the one case in which it would maybe not be grandfathered. And in 5.3, it says conditions constituting a violation include, and they describe maintenance and not maintaining improvements and construction without a permit. But if I could read the last sentence of 5.3 subsection C, it says, conditions constituting a violation include, but are not limited to. I have an issue with but are not limited to, because regardless of what you guys think, the next administration could toss, it's a loophole as big as an emergency vehicle. So I would love to see that fine-tuned a little bit for administrative reasons or whatever.
This one.
Yeah, and Shree's highlighted it on the screen too.
Okay.
So that's my input.
Well, thank you very much.
Yeah.
I will make one comment, just a quick one, about this is, so we know the grandfathering in the police power ordinance can't be perfect, right? When we're gone, right? We're going to, or at least I will be asking, and some of us are interested in, when we're done, we'll have this, we can send it to the planning commission to see if they can put things in the zoning ordinance to make it a little more, so yes, we are paying a lot of attention to grandfathering and things like that. So, thank you.
Thank you.
Okay.
Yep.
Hi, my name is Bill Zolkowski. I live at 6172 Webster Church Road with my wife, Susan Hawley. We are one of 4 families that live on one of the non-compliant roads, way predating the permit days. And I just have questions also about vague language that seems to go back and forth about what grandfathering means. Right off the bat, in the first memo that covers this, we talk about structures that were not lawfully constructed, whether due to lack of permits, and there were no permits when our road was made. We know that it's at least 50 years old, and maybe older than that. That was one piece. And then there's 2 statements that seem to, despite all of your claims about wanting to grandfather things in, to want to gradually kind of push us toward compliance. The one about section 1.1, article 1, purpose and intent, procedures to improve safety and reduce non-compliance of existing private roads or shared driveways. And that seems to be echoed again in article 4, section 4.1, letter C. It further intends to bring such non-compliant access, with an emphasis on non-compliant private roads, into compliance with the requirements of this ordinance. So those 2 statements, along with the definition in Shree's memo that covers this, seems to once again open up a lot of space for interpretation for those of us who, as I say, have these roads that have been there for a very long time. I might add that for 33 years now, we've had an informal maintenance agreement amongst all of us. It's worked perfectly well. We are in the process of formalizing that. It's on paper now, and we're just trying to get it stamped and approved. So, once again, I appreciate what you folks are trying to do. It's awfully complicated.
Thank you. Did you get that? You have where he's at? All right.
Thank you.
Yeah.
So, which one is that one? What page, just
on section 1.1,
Okay,
item H that talks about.
okay, I remember seeing that.
Good evening, board members. My name is Connie Olson. I live on Jennings Road on Independence Lake. So what I'm figuring out, so we're clear, so what you all are saying is you want to grandfather in existing private roads unless the following blah, blah, blah circumstances occur. And then this general ordinance can be changed tomorrow by a simple vote of y'all, not the property owners. So what I'm feeling is this is not protection, it's a promise with a loophole. In other words, we homeowners on these roads that we moved in there knowing where the trees were and all that, now we don't have the decision-making capacity. So the only permanent way to grandfather small private roads is through a zoning amendment, not this general ordinance with cartoons and figures and what have you. No, zoning. So I feel like you guys are trying, and it's probably in your heart to do the right thing, but that leaves us on the private roads exposed. And we don't want to accept a solution that can be undone later. And what you're doing is making it complicated. We want to keep it grandfathered. I learned what grandfathering was from my own grandpa, and again in the Army. What real grandfathering is grandfathered, period, end of story, not grandfathered with exceptions. We don't want our roads changed. That's why we live in the country. Once these mature trees are gone, it's too late. I lost a couple big trees after Barb Bukowski passed away. I mean, some of you guys know her, you know Sheila. So, you know, we want these trees. So I'm just asking, just get this on zoning so we can feel protected with what we have. Thank you.
I think I might have jumped the gun with time for response. So that actually is right after what I just said. Yes. Zoning ordinance. Okay.
Good evening, Peter Stevens, 7500 Trotters Lane. I know I brought this up to the board before, but on your website where it lists the difference between the zoning ordinance and the general law ordinance, for applicability, it says under retroactive that existing activities may be required to be brought into compliance. In other words, they may not be grandfathered. I guess there's maybe a typo there. What I've taken this to understand is that in all of these policing ordinances, the general law ordinances that you've written, they become applicable, township-wide as soon as you sign them. Everybody has to follow the standards. I don't see how you're telling the public that by passing this general law ordinance, you are grandfathering these properties. You're not. As people have said before, you're grandfathering unless. You are not allowing these roads to stay as they are. Listening to your conversation right now, perhaps you can answer this if you're going to answer some questions tonight. Trotters Lane is around 1,700 feet long, so well over your 800 feet. There's probably about 60 feet of it, if not well more. That's about 12 feet wide. Now, if I'm reading this general law ordinance correctly, the zoning enforcement officer could come out onto Trotters Lane, look at it, report to you that it's not wide enough, and we could potentially be forced then to repair the road to the current standards of the ordinance. Is that correct?
No.
Oh, wait, so it is in the ordinance we have right now, not in the one we're thinking of passing.
That's why we're doing this.
Yeah, that's one of the.
You are totally
that's
correct.
exactly
It's right now. It's like there's not. So you can grandfather. So first of all, splits. Even if you put in the zoning ordinance, splits are not grandfathered. They don't exist right now, right? So in zoning ordinance only.
But if you're, I'm asking about section 5.3 at the end, where it talks about the enforcement methods of this ordinance.
This one.
It says right there that the standards of this can be reported. I ask you to please pull it up and read it.
I got it. Okay.
It says, the township may initiate an enforcement procedure upon receipt of a complaint, identification of potential violation by any of the following: someone on the road or someone at the township saying there's a violation of the current road ordinance. If you're telling me that that is not language that allows the township zoning enforcement officer come look at Trotter's Lane, say it's not in compliance, come back and report to you, and then you take steps to force us to update it, I guess that language should probably be corrected. Now, the last part of that, which I seem to find the board glazing over, is that in the current road ordinance, the current general law road ordinance for the township, there is no language in it about the special assessment district that's being added in this draft. Now, I don't know if people in the audience are aware of what this special assessment district language in this draft says, but again, unless someone would like to correct me, my understanding is that in the circumstances I just described, the zoning enforcement officer comes and looks at Trotter's Lane, says we are not in compliance, reports that to the board. The board is then in a position where you can apply a special assessment district to all residents on Trotter's Lane through a court order, which just adds the cost of whatever repairs and upgrades the township deems fit and applies those costs to the taxes of the people living on the road. Is my understanding of that correct?
No. Okay, so first we'll go back to the, because there's two questions, right?
Thank you.
Oh, you're done. Oh, well, no.
Someone's
Okay.
gonna have to pay for it.
What?
It's gonna be
Oh.
the residents.
If my time is over,
Yeah,
I'll
for
sit
that
down
part,
and
that's-
allow other
that's
people
my
to speak,
You
but I
could come back up.
certainly appreciate an answer to that.
Well, the question, there again, answer the
I
question.
just want to, the first thing, when you're talking about 5.3, I also want to point out that it basically says when a property owner, when it comes out, potential violation, and it's based on a property owner most of the time when you're talking about that. And that's if somebody is sitting there and they're on a private driveway, you're 1,700 feet, you said, and one of your neighbors decides that they're going to dump a whole bunch of aggregate on the road because they want to put it, you know, on their house driveway, or it's a bunch of dirt that they're using for their beds, and it stays there for several years or a period of time that everybody else has to drive by it and starts restricting the road. That's what that is for. Or they abandon a car there, or something that restricts it, or
suppose that's not how I read it, so perhaps the
Right,
board should
or-
look for more clarifying language.
or
as
if
part of
that
the
particular
ordinance.
property owner
That
is
just sounds
in.
asinine.
What's that?
One at a time. That just sounds asinine.
But it happens all the
Wait,
time.
wait, we're not doing this.
All right,
One
I'll
question,
sit
one
down.
person, but we are answering. So, thanks, Joe. So, okay, so I'm gonna have to unpack this a little. So first, the maintenance, so enforcement for existing private roads are for things in 5.2. So 5.2, we made it as minimal as we could. Left tree kept clear of overgrown vegetation and overhead clearance. That's for fire trucks and ambulances. And then if you have, so routine maintenance, we're happy with. So that's A, 5.2A, happy with it. B is like basically don't scratch my $1 million fire truck. C, or our $1 million fire truck, I don't know. And then C is if when you made a deal to do anything, you have to keep with the deal, right? So if there were conditions when we say, here we go, you can do the split, which is pretty much what we do at that point, it'll just be for split, you gotta keep that up. And if you have a turnaround, what Jeff is basically saying is, we're not gonna let your neighbors park their RVs on it, or throw all their construction debris on it, right? That's kind of it, okay. So, and then the other thing about special assessment districts are, so there's rules about them. We can impose one. We can basically say, yes, either for whatever, you got giant potholes and no one can go through it, and you guys aren't agreeing. We can impose one. However, there's a way for the people on the road to actually stop us. I'll talk about that. But what it also allows for is, so we're not that interested, as far as I know, none of us are interested in it. What it does allow, though, is if you are on a private road and you can't get your neighbors to help you maintain, and we've had a couple of those, one in particular, that if 50% of the people on that road want a special assessment district, we can we can help you do it.
Yeah,
And John, of course, John's not here right now, but it would go on your taxes because basically you'd be, either we could loan, there's a reason we could loan you money and then you pay it back. It's like trying to help you. We cannot just build out your private road. That was one of our initial ideas with our road funds, but we can't do that. We're not allowed. So it's really not us coming and imposing special assessment. I mean,
the one we have.
there are other rules for that.
The Scully Road, right? When
Yes.
Washington County abandoned the north end of Scully, made it private. The Scully Road owners, property owners came to the township. They put that together, in fact, and it's been successful as far as I can tell. Now, they don't generally seem to get along, which may or may not always be the case. But it's not meant to be draconian. And the comments are well taken with regard to language, so we can adjust to what we're hearing. But it's not meant to create a bunch of loopholes we can drive trucks through. It's meant to be fair for both parties, and all parties concerned.
Oh, and I had to add another thing. Even if 50% of the people want a special assessment and we say yes, the people who don't want it can try to go to the tax tribunal and say, I don't want to be in it.
Yeah, I was just up on Merkle Court now, it's still there. If anybody lives up around Merkle, or off of that, there's a big drainage swell there that people are having trouble getting through. In fact, there's a red cone down there now in Santa Claus Avenue. And, eventually that could get bad enough that you can't get through. And my biggest worry is all this is geared towards make sure we get 2 fire trucks past. We don't have fire hydrants. If there's a fire, one truck goes in, uses the water, needs to come out, and at the same time another truck's coming in the opposite direction with water to keep going. If they can't pass, we have to try to figure out where one can pull over and get by. That's what guides a lot of us. That's what keeps me up.
Okay, thanks. All right, next question, please, or comment. 3 minutes.
Before I begin, I was just curious, is this being recorded to where it will be reviewed later?
Well, we have an audio that you can FOIA if you would like.
Okay, but it's not something that is on your website?
Oh, no, we don't have a camera yet.
You don't have that capability? Okay. And
Peters?
Yes, Peter.
Oh, okay, so you can get Peter in back there.
Okay.
Officially, no.
Okay. And other question is, the attorney of record for the board present?
No.
Okay, thank you. This is my 3rd time discussing these matters with members of this board. And I like to say greetings to the board. I come before you once again with grievance and remedy. Since the last meeting, I have not received any emails, phone calls. No one has reached out to me, so that's okay. But I want to make sure that we all understand there's a lot of information that you have left out of this, and I don't think your attorney has addressed it correctly or at all. I want to bring this to your attention. So each of you took an oath to the supreme law of the land, the U.S. Constitution. So what does that mean? It means that you are duty bound to adhere to the terms of the Constitution. For so long as the Constitution has life and power, it does not yield or bend to treaty or circumstance. Downsby Bidlow, 182 U.S. 244, 1901. To be clear, our founding documents, the Declaration of Independence, Northwest Ordinance, Article of Confederation, U.S. Constitution, Bill of Rights, is a trust indenture. We the people are the grantors, and we the people are the beneficiaries. All public functionaries, like yourselves, are the trustees. As trustees, you have a fiduciary responsibility to the beneficiaries, we the people. That said, part of that fiduciary responsibility is to guarantee a Republican form of government, not a democracy. Furthermore, you have
Can I just say, is this related to the private road ordinance?
Yes, it is.
Because we made very specific,
It
this
is.
has to be
It
private
is.
road ordinance related.
Yeah, oh,
Okay,
you missed
it is.
It is, but
I will tie it all together.
keep
for you.
going.
3 minutes.
Well, I'm here to air a grievance, and a grievance by Constitution has no time.
Are you a resident of this township?
I had a feeling that was going to be raised. Let me make it clear. I'm associated with a property on Dinser Road, 11 plus acres.
Builder.
It is owned by a trust. I am a trustee of that trust.
Okay, keep going.
My name is Mike, by the way, in case you forgot.
Mike, well, I'm sorry, what's your last name?
I'm sorry?
What's your last name?
My family name is Bambas, B-A-M-B-A-S. Now, part of that fiduciary responsibility is to guarantee a Republican form of government and our democracy. Furthermore, you have a fiduciary responsibility to protect and preserve our rights given to us by God, not the government. We are here today to determine whether this board has delegated authority to create ordinances that regulate private roads. You have been very adamant that it is private. Private means just that. You've talked about grandfathering. You better do some deep dive on the grandfathering. You have to go all the way back to the original land patents of all the properties. That's where you're going to have to grandfather back to. Not 50 years back, not 20 years back. You have to go all the way back to the inception. The question becomes whether this administration has territorial jurisdiction. And what is territorial jurisdiction? Does this administration have financial vested interest in private roads and driveways? No, you do not. Does the administration have equal or greater equitable title in the private land on which these roads and driveways exist? No, you do not. If this administration cannot show where it has financial vested interest or equal or greater equitable title in the land that these roads and driveways occupy, then you have failed to prove territorial jurisdiction. And you have failed to prove that you have delegated authority to regulate private roads or driveways. I'd like to remind this administration that you are mandated...
Sorry, it's time.
Oh, let him talk.
I can't, then I have to let all you guys keep going, and nobody else gets a
You
chance.
can have my 3 minutes.
You can't. All right, go ahead, keep going.
I'll make this as fast as I'm going to.
It's not new, he's already made these.
Well, no, we've heard, see, this is the thing, we've already heard this, just so you know. So, we haven't, keep going. Go ahead, keep going.
Okay, thank you.
I'll be
Thank you, everybody. I'd like to remind the administration that you are mandated to act as jury at all times pursuant to the U.S. Supreme Court ruling in North East Shelby County 118 U.S. 425 of 1886. This board is attempting to rely on what is called police powers, which the power of the government entities is to safeguard public health, safety, and welfare. However, police powers can never infringe, restrict, or impair any unalienable right. To do so is an act of usurpation. Pursuant to Norton, there is no immunity for any public functionary who does not act as jury in such public functionary by acts of commission or omission to be held liable for money damages and removed from office because of their violations of his or her oath of office. Norton continued, an unconstitutional act confers no rights, it imposes no duties, and affords no protection to any public functionary that have acted as usurpers, violated the United States Constitution or the state constitution, and removed from office having committed such acts. Pursuant to Ex parte Young, 209 U.S. 123 of 1908, the attempt of a state officer to enforce an unconstitutional statute is a proceeding without authority and does not affect the state in its sovereign government capacity, and it is an illegal act. And the officer is stripped of his official character and is subject to his person to the consequences of his individual conduct. The state has no power to impart to its officer immunity from responsibility to the supreme authority of the United States. Surety Roads amplifies Ex parte Young. So I'm going to skip over a little bit here. Now, do you understand what I'm trying to explain to you? I'm trying to make you from making a very big mistake. I brought this up at the last meeting. You have a neighbor in Livingston County, Genoa Township. They are currently under investigation. They are being and will be continued to be hammered with federal lawsuits. Why? Because they usurped their authority in what they were doing. I am a part of those lawsuits. I want to make it perfectly clear that this is a constitutional issue, making it a federal issue, not a state. The township is an appendage of the state. So if your attorneys, your bar attorneys, think that, well, we'll just force everybody by a lawsuit, understand, being an appendage of the state means that pursuant to Article 3, Section 2, Clause 2 of the U.S. Constitution, the original jurisdiction lies with the U.S. Supreme Court, not the state courts. Further, my associates and I have shown and proven over the last 3 years that every man or woman wearing a black satanic robe claiming the title of judge at the state level is not a judge, they're an administrator. Why? Because number one, they don't have a proper oath of office pursuant to Article 11, Section 1 of the Michigan Constitution. Next, they don't have an anti-bribery statement on file. They don't have a foreign age registration statement on file. And pursuant to Article 6, Section 19 of the Michigan Constitution, they do not have a license to practice law. It does not exist. The U.S. Supreme Court has ruled as such. Further, under the Supreme Court administrators, which created the State Bar Association in 1935, placing that under the 1908 Michigan Constitution, no language exists for it to be created. Now, how does this all tie to your private roads? I'm trying to let you know that if this gets carried away, and I'm offering free of charge to this board my assistance in helping you act de jure and provide a Republican form of government to these people, and I'm not going to charge you for it. I'm here to help you, not be an adversary. So, as far as the private roads, again, the remedy also is that you talk about the costs. My associates and I can show not only this board, but these people how to defer the costs so there are no out-of-pocket costs to anybody for any of these improvements. I told you this last time. Nobody reached out. I'm saying it again. So I have a project on Windsor Road where the road narrows after the curve. I have the survey. I'm going to widen that road to the minimum 18 feet across that section of the property. Not because of your ordinance, because of common sense. Self-governance, that's why. I don't need your rules and regulations. I can self-govern just fine without you. Thank you. Are you?
Okay. So, I just wanted to let you know, we've all heard that before. It'd be really nice if I didn't have to pay $500 a year to the state bar for my license, but that's really not. Let's move on. Okay. Next question, please. Or statements, either way.
My name is Don Wake, and I'm at 8206 Woods Trail. There's about 7 or 8 residences on that road. And my question is, when it says all private roads are grandfathered into this, does that mean that our road cannot be touched by the county or by Webster Township, that no one can come in from those organizations and tell us what we have to do with it?
No, the answer, so the first question is for the county. They do not deal with private roads.
Okay.
You could ask the county to accept it as a public road, and they didn't handle all the maintenance. But normally, no.
I'm just making sure I'm covering everything
no,
here. Because I haven't read through every one of your 1,000 paragraphs there.
So, and then
my question is,
about us, right? You want to know about us?
yes,
Okay.
can you come into our private road that my understanding is grandfathered in, so it's not included as part of this proposal? Can you come in and tell us what to do with that road?
Okay, so first, if there aren't any splits, there are no splits. The only thing that we can come in under this is under 5.2 maintenance. Right, so
yeah.
it's kind of limited, very limited.
Yeah,
If you
are
let's just,
saying-
yes, so
The existing road,
existing
as
road.
it stands right now,
Yes,
with the residents and the makeup of the road, can you come in and have us, make us mandatory requirements to make any changes to that road?
to make it change,
Yes?
no.
Take
Make it
down
wider,
Take down this train.
No.
Tree, widen the road.
No.
Whatever.
no. The only time that we would have for an existing road today, be if one of your neighbors wants to split, and then the other things kick in, would not affect you as a neighbor having to do anything. It would be up to them to have to jump through the hoops, depending on what they want to split and how big. But no, normally, no. The only thing for existing roads is the straight up maintenance.
Because I asked this selfishly,
Oh, no.
in the sense that I'm retired.
Yep.
Majority of my income is Social Security, and I have no interest in more putting up stock or be a welcoming man at minors. You know, when I purchased the property, I knew what I was getting into. The road is well maintained. All the people living there get along great, and we take care of it. So that's where I'm coming from.
Yeah, in that case, possibly you're not gonna hear from us.
You're not gonna hear from us. I live on a road just like that.
Yeah, it's really a beautiful room. So I'm gonna say this before we do anything else too. So unlike the state or the federal, the senators, we literally all live here. There's three of us are on private roads, and I've got an even weirder situation. So these rules we also have to live with. So we are very cognizant about, I don't think, Shelley would like to make her road wider. It's a beautiful road, it's not quite wide enough, right, or whatever. So it's like, this is why we're doing this. So, okay, next question. Or Dave.
Hi, Mike Burns, I'm corner of Lucy Drive and Mass Road. Basically, I just wanted to touch point on the private roads with the existing grandfather clause. Ours has been there for quite some time. It just still gives a little bit of uneasiness that the board still has the case-by-case basis to say if a property splits on that road, which can be done, whether or not they can force the whole road to upgrade. Ours has power lines, utilities, everything on one road, other residents on the other side. So if one house split and they had to upgrade the road, I don't see how you could upgrade with all the utilities and all that and not force the whole road to upgrade. I feel like there should be maybe some verbiage to say under certain circumstances like that, which would then drive financial costs through the road for everybody. Then the board could say, nobody on this road could split or something like that.
We can't deny your split, but I mean, for that reason alone.
Yeah.
And we don't want to, and we have built in,
Yeah, we have review standards so that.
we
we're
can
not gonna
say
take all
no
those trees down and do that.
to fixing the road, to upgrades.
But
to the
essentially
road.
that would block the split, essentially, right? 'Cause
That's the point.
we just
We
don't-
can-
Oh, it would just say the
We
road
would
stays
say
as
fixing
is.
this road in this particular way is not feasible. It's not feasible, but we might have, what we would look at first is if that person who's splitting the property can do something on their portion of the road reasonably, we would ask them to do that
Yeah, we
on their blocks
Yeah, we
there.
just had that example with north end of Scully, right up against the Livingston boundary. There was a split up there. We made he did some mowing, ground out his driveway, didn't have to take trees or move power lines, something like that. And I could envision,
Yeah, that's true, yeah.
I mean, if you could put a turnaround or allow a truck to pull over, a fire truck, I think that's reasonable. Once we start talking about everything you talked about,
Yeah, I just
I'm
was
sure
worried.
they know on that.
Right.
A split that's kind of out of my control could then come all the way through the whole road and try to upgrade.
No,
Just cause that
that's the
damage.
point.
That's what the rule ordinance says, that's what we're trying to
And that's-
prevent,
yeah.
because then it makes it really hard for people to do what they need to do. Yeah.
Thanks.
Mike, can I? He did raise a good point. I think we don't have utilities in the standards of review.
Oh,
Maybe we
yes.
can add that.
Yeah, that's a good question.
You don't have what?
One of the, like when the board is determining when discretionary improvements are required, we are saying that we won't ask you if there are any physical limitations, like if you're protecting natural features of vegetation, then widening the road is not feasible. I think existence of power lines and utilities,
Yeah, that's what we want.
it's under standards of review, section 4.5.
Yeah, fair enough.
Where we talk about easement restrictions,
Yeah.
natural features, we should probably add
Utilities as well.
public utilities.
Great idea.
Mentioned many times.
Okay. Yes, please.
Okay, so that does, I live on the same road.
Okay.
And I have a splittable lot.
Okay.
So,
Name and.
my name's Andrew Picnic, live on Lucy Drive, and yeah, thanks for bringing this stuff up, because it is, that's one of my concerns. There's other ways. Overall, it looks like the grandfathering, the the intent and where it's moved is largely in the right direction. Like, I definitely wanted to be angry, you know,
It's okay.
you know, but I guess I'm coming to terms with it, especially with recognition and other clarity on the costs that would be involved in this, because, you know, there are some questions now, like if police, can police and fire access my house today? And if not, can I have my taxes back? And if they can, you know, increasing the constraints seems a little bit weird. So it'd be nice to know what those discretionary upgrades, what are those conditions? And it seems very, so it sounded like maintenance was one of the concerns. And so, you know, that's small ball, like getting a pole saw and making sure that a low-hanging branch is taken care of, no big deal. But if a split comes in and then all of a sudden triggers this, you know, we're talking hundreds of thousands of dollars, and I just put a septic field in, and that would have to move potentially. Like, all this stuff just cascades. And so,
Shoot that map up, please, Tom. The map, like his case, or where we show splits. Sorry, go ahead.
yep, and so it's just one of those ongoing concerns, and there are implications for property values. If all of a sudden I think I have, you know, $800,000 property, but it costs $120,000 to come into compliance, that's I don't know, that could be something that I need to, you know, address with the assessor. So really the grandfathering doesn't seem to exist for any roads on which splits can occur with the discretionary clause. And so further review and specification is what I'm looking for in these documents. And yeah, I think that's my key.
Okay, thank you. Well, I'll go first, unless someone else wants to. Because this is a really good question, and this is kind of why it's taken us so long. Part of the problem is, so we started out with something like, all right, well, what if you're splitting into 2? Okay, we don't care. What if you're splitting into 4? Maybe not. What about 10? Then it gets a little shaky, right? The more people, the more, you know, right? All of a sudden now there's a lot more people on that road and it's too narrow or whatever. We couldn't really come up with, at least so far, a more flexible method. So what we looked at, for example, say you want to split into 2. We're like, oh, that's fine. Well, what if you want to split those 2 into 2, or that 2 into 2 after that, right? It can be cascading. We were trying to avoid kind of that idea. But and I have no problem with keep working on trying to make that tighter language. But right now it's kind of built in, as far as I know, to make us able to like just look at the situation and what the split's supposed to be and what that's going to do to the road and the traffic on the road, and give us enough flexibility to like try to match all that to like basically safety, right? Public safety, access, ambulances. So
Yeah, so Mike, right? Mike, so like Mike's question is, I mean, ideally, like if all the red is all overgrown, power on both sides, say on the, the bottom of the slide, is that the intent here is we have the discretion to leave all that alone. And if Mike's doing the split or he's going to be in the green, we have some green done if we can, where we actually put in a turnout or cutout so we can have a truck pull over. If there's a fire, the worst case is a fire is over at E1 or at the top of that cul-de-sac. We have trucks trying to race in and out of there. If one's coming out, it's only 16 feet wide and it's spring. Nobody's getting in until that truck comes out. So ideally, because it's wet on all sides and all that.
They could pull in the driveway.
They can K-turn in there, or if they can just pull over is what we're interested in. But our interest is to talk about that.
okay. All right. Next comment, last question.
Carol O'Donnell, I live on Woods Trail. My question is, how many houses in the last year have been lost because fire trucks not being able to get down the road. We have private roads. You say fire trucks can't get down, but how many houses or structures are lost? How many fires did they go to last year that they could not get back and forth on the roads?
In the last 50 years.
In the last 5 years. Can you tell me how many in the last 5 years that's affected?
Yeah, there are very frequent structure fires, fortunately.
Right.
Most of the emergency services are to address medical issues.
And they usually can get down the road to the other side, basically, of the car. Most roads, ambulances can get down.
And typically, a fire truck will show,
Yep.
as well as an ambulance, or 2 fire trucks will show, because there may be only one firefighter in one of those vehicles. So that is the majority of the calls that occur. So it's not necessarily fires that they're providing service for, it's health.
Okay, so how many times does an ambulance who's already down at the house get fire trucks that pull up? How many times is that ambulance not able to get out and the person died? I mean, let's be reasonable. They're not, we don't have houses burning down because fire trucks can't pass each other on a private road. We don't have ambulances not being able to get people back. My neighbor, a week ago, had 2 ambulances on a fire truck. They were able to get her out. The problem is sometimes, is Jennings Road is so full of potholes, that person going in the ambulance is in more danger going down that road. Southern Road, that's for sure. 5 years ago, Webster Township had the opportunity to have Jennings paved. The county was going to do it, the fire was going to do it, but you didn't want to do it. Now you want to make private roads safe. These county roads, or Webster Township roads, the dirt ones that are Webster Townships, are a mess. But you're worried about private roads. This is just, it doesn't make any sense to me. And I don't think it makes any sense to anybody who lives on a private road.
The roads in the township that are, the county road, the county has the obligation to maintain them. Now, fortunately, there was a millage that went before the voters who supported the township having funds to help improve roads and
Yes, I'm
Sure.
the chair of the roads committee. So the village provides, this year, it's $663,000 of funding. We're a second year in. And that's going to be spent at that level for 10 years. So what's on, there's maps on the township website. We have 45 miles of private dirt roads in the township that are needed to address all that. So we're planning on getting through all those by 2028. In other words, to go and get substrate on everything. So this year, the west end of Gregory's being done, Chamberlain, the north end of North Territorial going up to Merkel. In the spring, a lot of those roads, it's like going into Deer Camp. So all those are meant to be addressed. Jennings was done 2016, 17 timeframe, back when the regional complaint came up. The interest is to be able to get to that now. Jennings is ready now. Unfortunately, there's certain portions, like the ones I just talked about, they have not had a Washtenaw County roads maintenance event in over 20 years. Kids have grown up there, graduated from high school, are gone, and didn't see an orange truck. But the road millage is meant to identify that. But at the same, so we recognize that as well. If we make the same comment, go down Chamberlain. Chamberlain's not 18 feet wide. But some areas it's going to be moved out. So we're addressing all those at the same time. As far as the fire, it's meant as a happy medium. So the point about when does it happen? We thought our house was going to catch on fire this Christmas. We woke up Christmas night to a house full of smoke. It turned out our furnace was trying to burn itself up. It didn't trip any of the smoke detectors. We had 6 fire trucks there at midnight. And they all got in. We had a turnaround in our place, but they were all there in a hurry. It wasn't one. I looked outside. There was everybody out there. Fortunately, we didn't have to do anything. You know, it's telling when they left the racks to go look for where they're burning, it's not the front door. They actually wiped their feet before they went in, which but you can imagine that could have got out of control in a hurry. So our interest is to find a balance with that. That's why we're not, the current ordinance is gonna make that whole road, this isn't even a discussion, that whole road, you gotta do everything. Then you gotta go talk to all your neighbors and get them all to agree. Right now, if something new is coming in, is that we can put a turnout or something like that we think is a reasonable compromise. All the points, the statistics, the last time we had a fire was what, the Schloss barn fire?
Structure was.
There was a fire this week.
Yeah, but they were lucky with Schloss, they got there and the tanker they got stuck going in.
It's not a private road.
I know, the point is, it's the same driveway. If you can't get the other way, there's not gonna get any water to that way.
Was that a private road?
No, it was over, it was Jenny's, we were asking.
What's the point?
The point is, it is infrequent, but right now, if that was to happen, we want to still be able to get somebody in there where we think it's a reason. That's all.
And it is happening with the private roads we have now. I'm gotta use Trotter's Lane because I used to deliver hay over there. Frequently, there is no passing. There's a part of it that you can't.
Pull over the side.
You can't. Some of it's just straight up woods and it goes straight down.
Fire trucks can't pull over on the side when it's
Right.
very wet,
So-
they get stuck there.
Someone backs
So-
up. So what?
Well,
Is it a private road?
and I get the someone back up, part of it, but the someone backing up when there's a fire in the middle of it is a problem. Or when you're trying to get in it, if I was coming down with a load of hay and an ambulance is trying to get the other way, we'd be hosed. I could barely back up. They'd have to back up. I'd have to pull into somebody's driveway, and then they have to go around me. I know that because I had to do that with a lot of other people on that road.
What?
They need to have their CDL license to drive that fire truck, so they.
No, I have a tractor. This is straight up tractor. Right, yeah, right. No, I would, I think, yeah. Unfortunately, no one lets me drive a fire truck. So, okay. But, so, I mean, for a lot of this, I do agree with Dan and Brant. You gotta have some way for this to work. It doesn't have to all be 20 feet wide, and it doesn't have to be like perfect. It's just, okay. But right now, he's right. If you want to split, you do the whole road, or you come to us, and we do the same thing we're going to try to do it in far more limited fashion. So, okay. Next.
I have a question.
Yes.
You said if you want to split, you have to do the whole road, but yet that's not what that match is split.
Right, that is in the current ordinance we have right now, you would do the whole road. That's why this is,
That's why we're doing this now, to avoid that.
right.
But you're adding traffic to the entire road.
Well, there have been one or two people who actually don't want this leniency and would like, a lot of people really don't want people to split on the road. And they would like us to keep it the way it is, but we don't, well, at least right now, we don't agree with that because we've seen the problems with what we have. Trees, unfortunately, gotten stuck with many of them. So, okay, anyway, that's all I got.
My name's Kent, I live on Lucy Drive. This is actually right about what you were just talking about. So we had a lot on Lucy Drive that was split a couple years ago. They built a big new house. So why did that not trigger our road being revamped?
Was it
before 2022?
No,
Oh, was it before 20?
it wasn't.
No, it was not.
It wasn't.
It was not. The house finished completion about a year and a half ago.
It would have been when the lot was split before they sold the property, right? It would have had to be before, when the lot was split?
I don't think it was before 2020.
I need to look into records to see how
So,
it happened.
Just curious, because, that would have been terrible
Yeah.
for us. So I'm kind of surprised that nothing happened.
Yeah, so something changed. Something's different. Doesn't seem to.
That was it.
Thank you, we'll check it out.
okay?
As you know,
I don't think so, no.
before me, application hasn't been very consistent.
Okay. Any more people? Comments? Questions?
I had a quick one, just the police power. Can you put a limit on the, you guys mentioned that you need the flexibility of police power now before you go to a zoning ordinance. Can you add, my suggestion is to add a timeline So we just know what we're dealing with.
Okay.
Forgot that.
Oh, thanks. Okay.
So I applaud these people that are so organized. I have sticky notes with some thoughts. I've not been involved, but I'm trying to read all of these documentations that have been made available to us over the last few days. So my comments are, I'm still sorting this out myself to decide where I really want to stick my feet in the sand. So I apologize if it differs from what you're thinking, but I think in general, the vast majority of the people behind me followed the rules. They played by the rules. They live in this township for a reason. They raise their family here because we like what is outlined a lot in your master plan. It talks about protecting agriculture, talks about protecting the rural historic values of this township. And when we chose to build out here, we liked the idea that if we built a private road, we would be tucked away, and the rules on the books were no one else could build because the rule was 3, right? 3 properties. So we followed those rules. And it kind of reminds me a little bit of laws, ordinances, rules, where the vast majority are good citizens and play by the rules. And then that handful, however many, I know that we keep saying that you've had to take so much, you know, you've had to handle so much from complaining people, that they've come in and complained enough that this board in your collective wisdom, you don't get paid enough, I'm sure of that, decided to make a change. Suddenly communication is available, emails are available, we're driving to all of these roads, but yet none of us on these roads were aware, at least I wasn't, I don't know about all of you, were aware that you were considering adding multiple dwellings to Webster Township. And it's a slippery slope, in my humble, not a real estate person, opinion. Because, I'm sorry, I'm confused, I don't understand. We're not considering adding a lot of dwellings, so I don't know where this is coming from.
Well, I'll finish, and you might understand by the time I'm done.
What it is. Yeah.
It's coming from the rule change that allowed more than 3 homes on a private road.
That's a shared driveway, not a private road.
Okay, on a shared driveway. Again, forgive me if my terminology is off base.
Because I have, my private road has many more than 3 people on it. 3 houses.
Okay, so my road has 3, and we've been told.
Not funny.
No, it is, it's a shared driveway.
Let her speak.
Yeah.
Just be quiet.
Go ahead.
You know, I applaud you in all your wisdom, I really do. I am not. I am up here as a citizen trying to speak on behalf of my family and my 30-year investment. I'm not here to debate with you. And I apologize for getting frustrated, but that was rude.
I didn't mean to be rude, I really did not, I'm so sorry.
So adding additional homes, because people ended up with land that did not follow the rules of Webster Township. They couldn't build on it. And you said, because you got so many complaints or whatever, that it came to this table here, this forum, and you made a change, or attempting to make a change. I think it's in, there's a moratorium right now, and nothing can happen until September. So that happened. And then I'm reading through the documents, and it starts talking about case by case. If people do decide they want to split, they can come to this board and they can say their reason, state their case, state what tax base it's going to bring to the township, how good it's going to be for everybody, because suddenly the township is going to get a lot more revenue, perhaps. Our roads are going to get beat up unless somebody has to do the true improvement, which the original ordinance was set up to do. So I worry about that. And I think that a deep-pocketed developer, and there may be one in this room, I don't know, is really listening closely to what Webster Township is doing. Because just 50 years ago, Novi was rural. Novi was a beautiful rural agricultural area, maybe 60.
No, 50. I used to play on Novi.
And look at it now, it is a show. To
So many of us live out here, and actually our families before us lived out here. And that's why we chose to be here. And I'm very concerned that, okay, I think you mentioned, we didn't like the current ordinance because it was too restrictive. So you all decided to change what we all built and lived our life around. And we just got to accept that. We had no knowledge. I don't know how many people came to you. Sari, are you a township employee? Yes?
She's a consultant. She doesn't even live in.
She's a consultant. Okay. Because I saw your card was zoning administrator, so I wasn't sure if that was a paid position by the township.
We have a consulting contract with.
Okay, so she's not.
She's a zoning administrator.
She's not a payrolled Webster Township employee. She is a subcontractor. Okay.
She's an expense for all of us.
All right. Because she seems to know a lot, and she's put together a whole lot of information. And I don't know who she's had to deal with. I know family members and neighbors who have sent people in, and I said this last time, so forgive me, I'm repeating myself. They were told, no, can't do anything with that land, can't build on it. And then the next thing we know, somebody came in here, his father came in here, month after month after month after month, and thus the rule got changed. The ordinance got changed. I'm nervous about it. I'm concerned that what this township is, the amazing thing that we have here, is in jeopardy if slowly but surely one more house gets built, 2 more houses get built. I'm going to split because the Constitution says I can. I don't know whether that's true or not. The state of Michigan Constitution or the federal Constitution, I don't know. I don't know that information. I'm just a person who raised a family, and I have a job, pay my taxes, and I maintain my road. I recycle. That's what I do, and I live out here for the reason of what this community brings. And add a house here, add a house there is one thing. Case by case, the township decides who gets to split and how many splits they get and what they have to do to the road. Oh my gosh, that's a whole lot of expertise. And I just wonder who's going to have that expertise to make those decisions. Because somebody thought they had the expertise to make this one, to add properties, add buildings to shared driveways, private roads. And I just think it's a slippery slope.
So I'm not arguing. I just want to. So what I'm hearing is that you live in basically a shared driveway. It has certain requirements which are less than a private road, and you're worried that it will there'll just be more houses on it. It'll mess up your driveway, road.
Talking in general, not one.
No, yeah, I'm talking in general because people that have property, I think, again, the vast majority, they want it so they can build their dream home and raise their family in this beautiful rural historic Webster Township. What this is doing is it's really raising the ears of developers who are going to start going, sniff, sniff, look what they're doing. There's a weak link over there. Let's push, let's push, let's push. And I don't know who in this room at this table likes this plan, who of you voted against it, who of you voted for it. I don't know. I don't know if that's public knowledge or not. But I can't imagine you chose to serve this community with the intention of developing it.
Okay, thank you. Okay.
I was going to say that there's a couple of things I want to sort of reassure you about. First of all, we don't, anybody can split their property providing they meet the requirements that the state government and our ordinance say they can do. They don't have to build on it right away, but they can split it. People often split it to give pieces of their property to their family. So that is, we can't deny somebody splitting their property if they meet the requirements to do it. We can say you have to build a road, but I will say that because the township really values, the people of this township really value the idea that we don't want developers in here, we have gone the way that we know we can go to try to prevent that. And that is approving the PDR millage. And what the PDR millage did was allow us to purchase and get grants to purchase conservation easements on properties, big properties, to prevent development. And that's the control we have as a township. We can't stop somebody from splitting their property. We don't have, we can stop if they don't meet the criteria to split it.
Well, you
But otherwise-
did, you have been stopping people because of the rule that said only 3 on a shared driveway or private road buildings. You want to change that, so that is opening it.
I don't think
Why are we
that's-
shaking our head no? Isn't that what the ordinance is?
No, I think there's a misunderstanding. Right now, you can, if there's only 3 houses, properties on shared, only 3 on a road, it's a shared driveway. So that's what it is. If you want to split and build another house on that property, then it moves from a shared driveway to a private road.
And then what?
Then you have to comply with what the private road stuff is. Then that person would have to fix the road in
Yeah,
front
so
of their house.
currently, that person has to upgrade the road.
The whole road.
Whole road.
Currently, they have to update the whole road. In the new ordinance,
and
they just have to update.
So when
what
you
is-
say we don't have anything to stop measure this, that is a stop measure right there.
It is
Well, that is why we changed it, because there were people who had legitimately split their property and wanted to build, and they weren't able to persuade the entire rest of the people on the road to change or to pay for the road, and then that prevented them from being able to use
So
their
the
property
new
the way
person,
they
the
wanted to.
4th person who should have to improve the whole road, they don't have to improve the whole road. What they have to do is get the neighborhood, the other 3 properties, to agree to share the cost of a maintenance agreement or to expand the road.
They do, and that is where we are not finding, that's really the rub. It's very difficult to get people to agree to that.
They don't want it.
They don't want it, they don't want to upgrade
That's
their
why they
road.
live out here.
Right, and so that's why that's, when we say people were complaining to Sri, that's what was happening. We weren't able to do the things that people in this neighborhood, in this township wanted to do. Because
This many people.
No, I think anybody who has a lot of property in this township wants the capability of splitting it, for their family members or otherwise. That's not a limited number of
I'm
people.
not opposed to splitting it. If that's that we end up with where we can all split our property, that's the slippery slope I'm talking about.
Well, that's.
Because
that
everybody's
exists
going to want to do it.
It's in state law already. We
Yeah,
can't
we
stop you
can't.
from splitting
Yeah, but
it.
you're stopping it because there's the expense of the road improvement.
Okay,
So
so I hear all that.
that's-
I hear, okay, so basically what I'm hearing, again, is, so we've heard a lot of people who are exactly the opposite. They don't want anything. But I hear your side too. And
I don't know if you do because I don't have a side per se.
Well, no, I
I'm
mean,
still
like,
trying to
what your
sort
word
it
is,
out.
what your
But
word is.
But I do think the vagueness in some of the wording,
Okay,
the case by case,
okay.
is a slippery slope.
Okay.
Because there's going to be developers that want to come in here
Okay.
and buy this agricultural land and split it up.
Okay.
But that's not, that's true, I agree with you, but this ordinance doesn't stop that.
No, it might if they come to your meeting once a month for a year.
Well, I don't know about that, a new developer coming in is gonna have to meet the criteria of new roads.
My understanding was somebody came to this board, this meeting once a month for a year and got the rule changed.
That is not actually
That's
what
not true.
happened.
That is not true. If I may, I know you're speaking in hypotheticals, but I think I know the context you're coming from because I met with your husband and other people who live on your road, and we went in great detail about what the ordinance was, what the ordinance is, and I also heard the concern. So I know you also are talking in general that might apply to many people beyond, but so that the board can understand the context a little, can I share our previous conversation with the board?
Sri, before any of that, can I get your name and your address?
Joanne. My name is Joanne Dinser,
Address and
9491 Dinser Lane. I was given it in bites just in case you had to write and keep up with me.
Thank you.
You're welcome.
You talked last time.
You talked last time.
So you talked last time.
I did.
All right, I think for your particular thing, because there is a lot for the evening, would you like to come in, we can talk with me and Sheree, and we can, because the two of us have talked about your road already. It is a very strange thing, so.
I
hear, but
happy
we
to
hear
do
like
that.
that's what I said was other people have told me they do not want this because they don't want all the splits, and they don't want all these other things, so, again.
you know, we like where we're at, everybody likes the ruralness, the narrowness of Trotter Lane, you know, that you all talked about, everybody likes that. But what we also like is rules that are rules and ordinance and laws that are in place, and we all follow them, and we all paid our price. And I heard somebody say something, and I may be not understanding the context of this, but a hardship, a financial hardship could be. So now, if somebody can't afford the road upgrade that is being brought down on them because of these splits, who decides that they, oh yes, they can afford it? There is really no financial hardship. I don't like that either. To tell me, after 33 years of building and maintaining a road, oh, you can afford this. Yeah, there's no financial, my money was saved so I could retire someday, not so I can build the road so a builder can come and, you know, put houses there. And I'm not saying that's what it says. I'm saying this is a slippery slope, and I don't know that we've thought about all of that when we decided to open this can of worms.
Okay, thank you.
You're welcome.
Okay.
Good evening, my name is Devin Chamberlain, I also live on Lucy Drive. I'm here to just let you know I think I have your answers. Okay? So here are your answers, right? So the old ordinance needed to be adjusted, right? The answer for everybody in this room is grandfather everybody else. Everybody's got a private road now. They're grandfathered, period. No ambiguity. And here is the new ordinance for new private roads and new shared driveways. That's your answer. Right? And leave it up to us when we see an issue. Maybe there's an issue with the maintenance. We take care of that ourselves now, right? We widen our roads, we make sure the roads are in good shape. Let us take care of that part, right? You're looking at the future, and that's great. I think you need to look at it as a new road. Here are the new standards for new roads. Everybody else is grandfathered in, no ambiguity, right? Okay. The only other thing I would ask is, so a split. I think we need definitions for split. What is it, 2 acres or 5 acres? Minimum? Okay. Okay, so I think it needs to be in there. And if you're not going to give me what I said is your solution, which I hope you do, define some of this stuff, right? Grandfather people in with no ambiguity, no ifs, ands, or buts, no case by case, and then define what triggers a split. And if somebody is going to split a property, it's their responsibility to make any improvements, even if it goes beyond their frontage. Okay. Thank you.
So I can try. Do you want to go? Okay, so I don't know, just unpacking that. What you said kind of almost 180 from what the previous commenter said. Because if we grandfather everything, then anyone who has anything on a private road can split to their heart's content without having to do anything. That's not what we have now, and that's not what's in here, but if we did that. And so what you're talking about with splits is what we're trying to do. I know that some of the wording is not the greatest. I mean, it is. We're doing the best we can. But that's the intent. That is actually the intent. Is to grandfather everybody who has anything existing right now into everything except for just maintain it. And then
make it more clear, sir.
Yeah. And that, yeah. And we've been working on trying to make that more clear. It needs correct. Yes.
And then get rid of the ifs, ands, or buts, and the case by cases. Right.
Yeah.
Okay.
You want unconditional grandfather, not conditional.
Yes.
Yeah. Simple language.
I guess what I'm getting out of all of this, sitting back here, is we want the roads to remain the same. We understand development's going to happen slowly but surely. But where I'm seeing this right now is, what you're saying is somebody comes in, a developer, buys up 11 acres, decides they want to split it into 4 lots. Now it becomes the problem of everybody on the road to make sure that that road's maintained and taken care of.
Not quite.
Where am I missing that?
Well,
Because
okay, so you're right, so it
you're
all-
showing that where their property is
Yeah, so that's the
is
green.
their problem.
That's their problem. The red might also be their problem. So the red will never be your problem.
Who just, yeah, I was just gonna say, I'll use for example, I'm Scott Denzer, I live on Denzer Lane. And I understand things are gonna get developed, so it's not like I'm trying to stop. I think personally, you guys are looking for tax breaks. But my point is once the traffic increases, and by the way, I do build roads for a living, so I've watched roads deteriorate. We have all maintained our road. Somebody comes in and buys the property and they want to upgrade it, we already had a rule in place whose problem it was to fix that road and upgrade it for the additional traffic. So I first don't understand why we all of a sudden said, well, you've got property on this road, so now you can build a house. Well, you're increasing the traffic, whether it's by 2 cars or by 20, it doesn't matter. The rule was in place. So for whatever reason, that got changed, and I'm not going to get into that. But you guys had a rule, and now you're trying to put, let's say, the electrical grid part of it, which one gentleman brought up. You know, I live at the end. You add 3 more houses. Well, actually, I already know that there's 2 building permits that have been issued, and the one person's trying to add 3 more. So now you're adding 5 more houses on the lane. What's that doing to the electrical? When does DTE come in and say, okay, everybody's got to upgrade it, when I've already paid to have gas and DTE put back there? Now, why should that onus become on me to have to upgrade that electrical system? And I guess that's where we're coming from. It's not that we're stopping development, it's not that we're stopping splits, it's going to happen, that's a natural thing. But who's going to pay for all this? We have too much open, well, the township engineer. Well, who's the township engineer today and who's the township engineer in 10 years? How do I know the township engineer in 10 years isn't a developer and he decides, okay, everybody's paying for this? You see what I'm saying? There's just too many open things here. And before you guys just start handing out building permits, which you've already changed back last fall, I don't think any of this was thought through far enough. And like I say, I appreciate what you all signed up to do, but we got to take it a little more step by step here, because we opened up Pandora's box, and now that everything's loose, you got a room full of people that don't necessarily like one way or the other. Thank you.
Well, yeah, we can bring that up. So the challenge that we have with the existing ordinance is it has been enforced sporadically, to be a point. So even in a case, we can take this case here. So say that the 4 green ones are new, and if that's it, and if the road ordinance wasn't enforced, say it's narrow along the whole way. The way that, if you enforce our current ordinance, that means whoever it comes in at the end has to pay to fix it all. And we all agree that that just doesn't seem fair, right? If there's one split that...
Excuse me, I'm sorry to interrupt you, but why was that not fair?
Because why?
I paid for it to build it originally so I could build my house.
Right. But if it's an added level that's not in accordance with the current private road ordinance, is that then the last person in has to bring it up to them.
Back to my point, who's going to be the decider of that? The guy that buys the 52 acres next to my house and decides he wants to put in 15 houses, and now everybody's got to build the lane so it supports his 52 houses?
Well, that's the case where we've talked about where there's more, is that as that number gets bigger and it's a big developer, then that onus increasingly shifts to that developer. But we've had other folks that have showed up here and has already had a lot or one split. They ask, why should I have to fix that whole road if the township hasn't required that they bring it up to the standard that's currently there? Well, that's the point, right? So that's not fair.
You should
Wait, okay, sorry, we gotta do it. Sorry.
I'm sorry.
One at a time.
You should read the rules that were in place before you purchase your property.
Yeah, buy somewhere else if you can.
I mean, that's why those rules are there. I spent tens of thousands of dollars to build the road originally. Now you're telling me I gotta spend more because the guy down the road wants to add more houses?
Well, you would never have to.
No.
You don't have to.
He would.
But that's not what you're saying.
No.
And you're not defining that. The rule that was in place defined that.
I think we gotta go to Sri with the language that supports
Yeah,
what we think we say.
I added a note to myself to make sure, go back and review the language to make sure that the responsibility of who completes the discretionary improvements is clear.
Okay.
It's
Our plan, again, we're still working on it, is if you live on a road, you don't have to pay to expand it or anything like that.
That's right.
Ever again. Right? It's to split people. The only thing you'd have to do is keep it up to where it is. Right? Which everybody's doing anyway. They have to get their cars out, right? Or whatever, unless it's crazy. But
Yeah, I mean,
we want to go court. But,
Yeah, right.
so the flip side of what you're saying though is one thing that really triggered this was there were already lots on these things where people would have to do the whole road. So they bought a lot or it got split 20 years ago or whatever, when there was an frontage requirement in the zoning ordinance and all these other things. So somehow these people they have land that they can't develop. Now if you tell people you bought a piece of land, can't do anything about it, then you have constitutional problems. That would be like a regulatory taking.
the rules were in place.
I know, but so the rules could have resulted in, and did result in people having just, the big one was the maintenance agreement, to be honest. No one could ever build anything that, any other existing house on anything, because nobody's neighbors are ever signing a maintenance agreement. So that's where so we kept having to give people variances. And then we started, and then Tree, of course, obviously all this falls on her to like start it up, give it to us. And so then all of a sudden, it's like, all right, well, why are we doing this? People can't build, they have to come to us. It's just a giant mess. And we didn't create, you guys didn't create these problems.
Yeah, right.
They just got there. So what do we do to make it fair for the people who own the lot and fair for everybody else on the road? And that's where we kind of are. And then we went, okay, splits are different.
If there's any existing homes on those roads, there's not any requirement they put in any more lines.
Right. And there is now. Like, so right now, and unfortunately I gotta use my best road over there, is like, unless Tree tells me I'm wrong, we could go, oh, there's too many. That's just too narrow. Everybody pay. Is that right? Or what we have now? What would we do?
No, I'm shifting a little off topic, but I wanted one moment to address one of the comment raised of, Shri bringing stuff to the board because residents complain to Shri. I want to say that my job, even if one resident complains, I bring it to the board saying, hey, I've heard about this, what do you want to do? It's up to the board then to decide whether, if that's something that's valid to take it forward into further discussion or not. I do the same thing with planning commission as well. Like if there was one resident who said requiring a fence around a swimming pool doesn't make sense. I went to the planning commission, even if it came from one resident, and planning commission talked about it and decided, no, I think we like the standard how it is. So I only bring it to their attention, and my job stops there. And then if they decide to take it forward, my job is to help them draft the language so that it captures the board's policy. So I just wanted to clarify that to everybody over here. I know I'm not from here, but my job is to use my experience and my education to provide them with data and options, questions to consider, pros and cons. That's my job. I'm not biased, I don't have an opinion either way, but I am biased when I hear a lot of people, I hear people and then I come to them. Strike the last sentence, I'm not biased at all, either way or not. But all I'm trying to say is, my job is to provide them professional information so that they can make an informed decision. That's where my job ends. Thank you.
Thank you.
Wait. All right,
Anybody else?
you guys are right. Right now, maintenance of private roads. Each private road shall be regularly maintained in a manner suitable for safe, convenient, and dependable ingress and egress for all properties served at all times, and shall be at all times in a condition that meets the minimum standards of this ordinance. Shelley's road does not meet the minimum standards of our ordinance. Yours probably does.
Well, most don't.
Most don't. So, right now, it's, again, like, what we have now is far more draconian than anyone's ever used it for, I think.
Yeah, that's right.
But right now, all bets are off, basically, and that's not what we want. Okay.
I'm sorry, Mike. You asked me a question, and then I used that opportunity to just
No,
share
it's
my
okay. I just
opinion.
looked at that. Oh, no, that was it, the whole maintenance. Okay, we're good. Okay.
Anybody else?
Anybody else? Wait, does anyone else want to go first? You guys been talking.
1 minute.
Yeah, oh, no. You can take your 3 minutes. I mean,
I
I know, yeah, it's fine. Well,
So, hello, my name's Nathan. I'm moving or building right now on Scully. I think some of you guys saw, I'm the new house on Scully. So, new to the community.
welcome.
From Canton, Michigan, love the area and stuff like that. 2 questions though. One is, Nathan, yeah. Kind of like, because I'm new, this is new to me, I'm taking it from like a top level view, is grandfathering has been a big topic of conversation tonight, but we don't actually define what grandfathering is legally. We assume, if I'm wrong, please correct me though, because I was scrolling through it. Like, I just, because I went to University of Michigan, I talked to other legal lawyers and stuff too, and there's benefits to defining what grandfather means, but there's also cons, and I think the board should kind of assess those, because if you define what grandfathered is, it helps solve what I think a lot of community members are thinking, but then if you don't define it, then there's gray area and stuff like that. So I would motion to try to analyze that. And the other thing I'll say, I know you made a comment on utilities. I really think that should be addressed. As I'm building on Scully, one of the biggest things is actually power to my house. So I flipped the lot, if you guys don't know. It was technically a timber lane address, but because of potential environmental impact with how the water is down there and everything else, the builder recommended, so I don't have a giant hill in my backyard, to kind of flip that house and make it a Scully road, or Scully address. One of the things I'm working through, my wife's a civil engineer, but is actually power to the land. And so one is I can route it from Timber Lane and go 5 acres underground, but then they have an easement and it's 12 feet wide, significant tree clearing, which is not what I want, right?
How much money?
Not exactly. And so the other opportunity is actually to route it up and over Scully and drop a pole on my land, which is the preferred method. It's simple, it's straightforward. However, DTE, and again, my wife's a civil engineer in the power transmission line industry, DTE is trying to very much limit overhead power and new development of overhead power. So take that into consideration when you guys are talking about road expansions and stuff like that from a utility standpoint. If that does trigger, you would have to work with DTE to start then going everything underground because they're limiting overhead development. And how you guys address that in financial burden and stuff like that, just please take it into consideration.
Thank you.
Yep.
Thank you. Okay, any more new people before we get to people who want to talk again? Okay, one more. Anybody?
Peter, you wanted to talk again, didn't you?
I'll be happy to after the gentleman.
You're going to wait for Mike?
All right.
Mike, come on up.
Just 2 quick questions. Does your township, through your charter, is it stated in your charter that you accept bills of exchange?
We are not a charter township.
You are not a charter.
We are a general law township.
I was, okay. Do you, in your decree, accept bills of exchange?
For money?
Yes.
What? You'd have to kind of ask the 2 people who aren't here, because I don't do money.
Okay.
It's a treasurer and clerk question.
Okay, they're not here? Okay.
Sure.
All think if you guys did accept bills of exchange, this would alleviate a lot of the financial burden that everybody seems to be concerned about. Second question, based on what I'm hearing from you guys, and based on what I'm hearing from the people behind me, why is this board opposed to self-governance?
Well, we don't have a self-governing form. We have a representative form of government. That's why the election.
We're to be a Republican form of government, Article 4, Section 4. As such, we the people self-govern. We only need you on certain circumstances, not to dictate everything we do.
Okay, so I spend a lot of time studying a lot of these things somewhere else. I'm just going to go with what the state and the state Supreme Court and the Court of Appeals and our attorneys tell us about how we do things. I don't know all the answers either, so.
I'd be leery about what attorneys tell you for the simple fact, pursuant to Corpus Juris Secundum, Volume 7, Section 4, first obligation of all of our attorneys is to the court, not the client. Regardless of how much you pay them or how well you know them, the first obligation is to the court. Now, this is why Genoa Township is in the pickle they are in. So I just heed the warning. So, but I would look into the bills of exchange. I think if you guys were to accept that, that would alleviate basically all of the financial burdens that people would be incurring from any of these changes that you guys want to do on anything.
Okay. Thank you. Peter.
Stevens, 7500 Trotters Lane. Just some observations before I give some final comments. One, I'm sad to see that John Scharf isn't here. I know through most of the conversations that this board has had about the private road ordinance, John Scharf has very vocally said that he believes the appropriate place for this kind of language is in the actual zoning ordinance, where it allows grandfathering, which is obviously the largest issue to the public here, which allows grandfathering indiscriminately. You're grandfathered if it's in the zoning ordinance. So I'll just go down the line. Just to say, Mike, I've lived on Jennings Road now for almost 40 years. I've driven a tractor with a hay trailer behind it, past garbage trucks, past other vehicles.
Oh, not in Jennings, on yours, sorry.
Or on Trotters Lane. I've passed all those people on tractors and in my truck, so I know it's possible.
There are definitely places, I'm not saying it, this one's wooded part.
Either way, I know it's possible. I'd still be curious, because I don't believe that there was an answer from anybody on the board about, has there ever in Webster Township's history been an instance when an emergency vehicle call was made for a residence and that emergency vehicle was not able to reach the residence? Has that ever happened? I would love an answer to that. Jeff, when you were discussing the issues of perhaps a derelict vehicle or bad road material dumped on a road, those are the kinds of things that, at least applied here, I view as considerable overreach in trying to essentially pound a hammer or pound a nail by using the 50,000-pound jackhammer you got in the garage. Like, if there's a broken down vehicle on the road, that can be something addressed in the nuisance ordinance under derelict or abandoned vehicles. If people are dropping crappy materials on the road, that can be addressed in the nuisance ordinance through illegal dumping or something else like that. It doesn't have to be used as some kind of application towards a road for maintenance. The road could be just fine. If there's a rusty car in the middle of it that doesn't allow emergency vehicles to pass, that's a nuisance for the township and for emergency vehicles. Again, just try and approach these things in perhaps the appropriate way. As many other people have mentioned, there's just a lot of vague language in here that gives almost the entirety of discretion in these cases to the township on what you think is a hardship on what you think is potentially a hindrance on that road and what you think are the necessary requirements to update and bring that road into compliance. That is the kind of thing that makes people afraid. Again, this is something that could be addressed, as was mentioned before, by having two different types of ordinances. Have a private road ordinance in the zoning ordinance that addresses current and past private roads. What everybody here, I'm guessing, doesn't want to see happen is developers come in and continue to build large, gigantic developments. Now, one of the things that I was thinking about during your discussion is that when you talk about that part of the road where someone is able to maybe split their lot however many times is legally allowed based off their acreage. If someone moves on Trotter's Lane after a split and they are required to do their part of the road, if they buy everything in front of me, all the way out to Jennings Road, and they want to bring that entire road up to code, that's going to be incredibly expensive. No regular private citizen is going to be able to handle a cost like that. But you know who is? Big developers. Big developers are going to be the ones that benefit from this when they can come in, buy large swaths of land that they can afford to buy, and then update whatever road they want to because they can't afford to. It's going to press down on the people that want to, like John Scharf or maybe other people in this audience, split their land for a family member in a small rural community, which is what we all want to live in. Finally, just as kind of a point of order, at your last board meeting, there was a document that you all signed on to very congratulatorily about the Township Organization of Michigan, the MTA, sending you something that is just how to govern in the township. In that were various things about bringing credit, honor, and dignity to the township by associating with your constituents and stakeholders in a respectful manner, and doing things like giving appropriate responses, and not being rude to the people that are coming up here. This is a public meeting. I would hope all of you guys know that there is no rule or law about 3 minutes. You can suggest to people that they try and keep their time limited so that everybody gets a chance to speak. But it's not you to time people and say, okay, you're done. It's not for you guys to talk about content. It's an open public meeting. You might have someone that comes up here and says something for 20 minutes that you don't like, but unfortunately we all gotta sit here for it. That's what a public meeting is for.
No.
If it's becoming disruptive, obviously there are rules about
We can
that.
set limits of time for public comment. And in this particular minute, no, that's not, anyone has ever told me. But either way, thank you for all the rest of it.
All that is to say, my final statement is, this really needs to be adopted into the zoning ordinance, at least insofar as the grandfathering portion. People don't want to just sit in their house worried who from the township is going to come and say if this road isn't up to specs, and this is what it's going to cost you to fix it in our eyes. So I hope the board would take the public's comments into consideration here and recognize that the overwhelming majority of people here are asking you to put the grandfathering portion of this into something that makes it easy for people to access. Thank you.
I do have, so for that last point, so John's not the only person who actually shares that sentiment. So we're still looking at that.
Okay, just a quick comment from Devin. It would be really interesting to see of the private roads, the potential splits that are remaining. What's that?
No, we're just thinking that's interesting.
Because I think on our road, we're talking about potentially 2 new lots maximum. And so, you know, is there some threshold of grace where if we're talking about, you know, a certain ratio or percentage increase potential where Lucy Drive could just be grandfathered in with all the potential splits.
Okay.
So, and anywhere else, that might just be an Excel query that says, 75% of these roads, there's no problem going forward, so.
Okay, thank you. Will do. That's a good. Okay. Yeah, yes.
I just have one, everybody talked about the financials, and of course, grandfathering is grandfathering, period. Let's do zoning, but actually for me, a lot of it also is about the quality of life. You see what's going on in Ann Arbor, they just keep building up, there's no parking. I'm originally from Los Angeles, and where I would go to be among beautiful trees was cemeteries and parks. So we see what happens in Saline, where people come in with data centers. So that's why we're really got to keep, it on tight, because if we give an inch, then we're going to get taken advantage of. And the quality of life is what has me out here and all those.
Thank you. Thank you. I'm going to reiterate, Shelley's, this is the plan to stop large development in the PDR program. It'd be awesome if everyone who had decent sized pieces of land could get into it, and okay.
Sorry, I just do have a quick question too, and sorry because I haven't been fully educated, but like, how does Scully with the road agreement, and that's one of the main reasons why I wouldn't have bought the land that I did without that road agreement, so it works for us, but how does that work when that road isn't necessarily like 18 feet wide? I was trying to find like the road documentation.
So Scully is a special weird case.
Okay, I'm learning as a new resident, so I'm sorry about that.
Scully was a public road.
Right.
Okay. For some reason, there's a developer in what's above Amber? Livingston County. So the people on Scully were very, very worried that it was going to become a major thoroughfare.
Yep.
And so they got the county basically to give it up.
Got it.
And when the townships, I looked at this, when the township, I'm trying to help with the next special assessment too. When the township took it, we took it in the condition it was when it was taken.
Got it.
Accepted.
Yeah. That makes
So
sense.
that's kind of, it makes Scully just a very special way.
Okay.
I was on the board when that happened. So we all went out there, the fire chief at the time, so like getting the truck in, this, that, and the other, and we also, well, you could. I mean, especially because you can't tell where the road is, all the beautiful trees.
It's all over the place. Yeah.
Now, we approved it as is.
Okay.
And then, and the residents, I forget how they came to us, the majority of them wanted it.
Yeah.
And John, treasurer at the time when he did, his predecessor, Karen.
I think my predecessor actually got my land out of the agreement, which then I opted back into the agreement because now I put the house on
I
it.
understand.
Yeah.
So that's the classic.
They found a tax, she found a tax loophole or whatever. But I was just curious, like, how does that, like, does Scully ever qualify to be upgraded or meet these requirements of the ordinance if it already has it, even though it's not 18 feet wide? I guess that's where I'm.
No, you're good. You're good.
You're good to go.
No, they're good.
They're good, but their SAD is coming up.
Oh, yeah. We'll still do the SAD.
Sure.
Because that's just amazing. Every 5 years or whatever.
Yeah. That makes sense. Okay, thank you so much.
But he was asking about it.
Okay. Anybody else? Yeah, we're a little over, so what? Okay.
Oh, I have one.
Go on up here.
All right.
Just one more little idea, sorry.
Don't be shy.
Peter Stevenson, it was just an idea that with the idea in mind of whether emergency vehicles have ever had difficulty actually getting to a property in Webster Township, it seems like that would be a really easy way for the township to have some kind of teeth if they go after a road. If an emergency vehicle tries to go to a house and they're impeded and can't get there, have them send a letter to the township and have the township take action against the residents. But at least until that happens, you're not getting up people's asses.
Thank you. Thanks. All right. Hold on a second, sorry.
She's got a question.
One question, just wanted to summarize the wide range of comments, at least at a high level, we got today. So we've heard from people who said, you shouldn't let somebody build a house on a vacant property without making them go through the upgrades. And we've also heard from people who said you should not make them go through upgrades before. They didn't show up today. And then we've heard from people who said allow splits with no upgrades, allow maybe up to 2 splits with no upgrades, have a threshold to allow with no upgrades. And then we also heard like allow upgrades with any splits or one, like grandfather the road and allow how many ever splits they are allowed for land division on that road. So that's just a wide range, so that's up to the board where you find the balance.
And the other one is cleaning up some of the language that's been highlighted, as far as unattended, clarity, summary.
Right, so there are some comments about reducing if statements, maybe try to reduce sentences to at least, take away the vagueness. There were some comments about clarifying the enforcement, what triggers enforcement, how the process works. It just feels like that anything, like there might be some, I felt like some of the residents felt that there's some language that's in small print that, that's gonna, so they wanted some clarity on that enforcement and that part. And then I think utilities was a good point to consider. It's, potential practical difficulties, that's a very good point. And then we did do the spreadsheet when we identified how many splittable lots are available. So we do have that data. We do have that data in our spreadsheet where when we identified the 44 roads, we said, okay, on this road there are about 5 splits left, or there might be. So we do have that data. The board wants to revisit that. And then the other one that was also, it's the major resonating theme that the board considered this ordinance is, how do we grandfather this? And then that seems to be but it just comes at it in a different perspective. So that was one, and then the one last but not, there were other comments too, but these are just high level I captured. And then the last one was moving this to zoning ordinance. So I just wanted to say, I know this is not a meeting, was just guided for public input. I just wanted to summarize when things were fresh in our mind. I did include a memo in your packet that talks about police ordinance versus zoning ordinance, what to consider. It can be in both places, what to consider, pros and cons when you decide that at, next possible meeting. So if there's anything I missed, let me know, but I think I noted more points than I summarized, but I just wanted to get a theme, capture the theme.
Thanks. Okay, so now we're at the board comments part of this anyway, so if you want to say anything.
No, I think we covered it. I think to get all those comments assimilated.
One more comment. I think one of the things that was overlooked in your summary is things being defined. There's a lot of loopholes being left in this on who's going to decide.
Yes, I did
and
that.
how the decision is going to happen. Because you all might be well-intended, but the next board might not be. And that's my concern, being a lifelong resident of Webster Township.
Yeah, fair enough.
Thank you. Okay.
Pending your thoughts or the board's thoughts. And this seems like once we get that list together, possibly give Fahey some direction, maybe take another pass through. Okay. Awesome.
Yeah. Okay. Sounds good. Anybody else?
I'll just thank everybody for being here and sharing your thoughts and opinions.
Yeah, you're here.
It's appreciated, and just wanted to share that. Thank you.
Okay. All right. So here comes the really weird part. So there's another general call to public right now. 3 minutes. Anything you want. Well, you also have next week in case you like, because we have another board meeting. So, does anyone have a general public comment they would like to make?
Yeah, so now you can talk about anything.
That's what's so weird about this one. Okay. All right. Thank you. Seeing none, I would like a motion to adjourn, please.
Move to adjourn.
Support.
Discussion. All in favor?
Aye.